Welcome to the Lawyer Education Series. I'm pleased to present this training on children's crime. My name is Hannah Murphy and I'm a solicitor at the Children's Legal Service based in Parramatta. I'm joined by Andrew Marriott, who is also a children's crime solicitor at Legal Aid New South Wales.
Thanks, Hannah.
There's often a misconception among some criminal law practitioners that the Children's Court is a wild west where anything goes and that the stakes are low. This couldn't be further from the truth. The ultimate punishments and penalties imposed in the Children's Court are not what you'd usually see in the local and district courts. However, this doesn't mean that the way matters are dealt with at these formative stages of a young person's life won't have life-altering consequences. Issues such as being convicted, being registered on the Child Protection Register, or even spending one night in a custodial environment are incredibly significant for young people.
It's a privilege to be able to work with young people. Advocates in this jurisdiction can have a profound impact on their clients. The children that often come before the court are often dealing with incredibly difficult situations, like being in out-of-home care, being a victim of domestic violence, having drug or alcohol issues, or suffering from mental health issues.
This training will take a closer look at important things to consider when working with young people in the Children's Court jurisdiction. We will cover the following topics: practical considerations for private lawyers doing duty work, the most important child-specific legislation, serious children's indictable offences and sexual offences, and finally we'll run through some important services offered at the Children's Court. Please bear in mind that this is in no way an exhaustive list of the things that you need to know to practice in the children's jurisdiction. Rather, it's aimed at highlighting some of the significant differences between acting for young people in the Children's Court and acting for adults in the local and district courts. This training is also intended to provide some practical advice for private lawyers doing duty work for Legal Aid New South Wales. Specifically, how private lawyers can best assist Legal Aid in these circumstances.
The first area we'll be looking at are things that you should consider when doing duty work in the Children's Court. This includes arrival time, the allocation of work, important etiquette to be aware of, completing the Legal Aid New South Wales form, whether there are any ethical differences between representing children and adults, finalising matters, taking instructions for release applications, and writing representations.
The first thing that you need to be aware of is your arrival time at the Children's Court. It's important that you know when you are required to arrive and the impact of your arrival time. You should make sure you do the following. Check with the relevant Legal Aid office about court start time. This is important because each court you are required to attend may have a different start time. And make sure that you arrive on time. This is important because in many situations you'll be asked to do fresh custody matters when appearing as a duty solicitor. If you don't arrive on time, it'll be unlikely that you'll be ready to do the custody matters by 10 a.m. We try to ensure that we have at least one custody matter ready by 10 a.m. If you're not ready to appear, you'll need to tell the court yourself or let the solicitor from Legal Aid who's managing the court list know, so that they can advise the magistrate on your behalf. This may happen in instances where you might be waiting for information about accommodation.
When you're appearing as the duty backup solicitor in the Children's Court, it's important that you're aware how Legal Aid allocates work at court. Every list day at the Children's Court will have a managing solicitor from Legal Aid who oversees the Legal Aid list and coordinates the allocation of files. The managing solicitor will direct you to what matters and files you should pick up. You should make sure that you regularly check in with the managing solicitor throughout the day, so that you can assist with other matters that may not have been provided to you on your arrival.
When appearing in the Children's Court, you should also be aware of the appropriate etiquette. There are two main differences in etiquette between the Children's Court and local court. The first is that you remain seated when addressing the bench. This is aimed at reducing the formality of proceedings. And secondly, you're not permitted to bring your client into court until the court is ready to deal with the matter. This is because Children's Court is generally a closed court. Given that it is a closed court, you should inform the magistrate of your client's appearance and any accompanying support persons before they enter the court. Make sure that all support people in the court are over the age of 18, and we also suggest that you introduce the young person by their first name. to minimise the intimidating nature of the court proceedings.
The next thing to note when doing duty appearances is the legal aid form. A legal aid duty form must be filled out and completed for every client that you provide advice to or represent. So, who completes the legal aid form? If the matter you're dealing with involves a young person who is in the community and hasn't been to court for their matter before, the court support workers may have asked the young person to fill in some of the form already. However, it is up to you to make sure that the legal aid duty form is completed correctly and thoroughly. When you complete the form, please make sure you pay particular attention to obtaining contact details. Young people are notoriously hard to pin down on their phone. Pay special regard to obtaining contact phone numbers and get as many contact details for the young person as possible. Record youth justice contact details if they have contacted you. Include notes about each contact person. For example, the young person may provide you with both of their parents' numbers, but only want you to discuss their matter with one of them. Make sure you make a notation of these instructions on the form next to the numbers provided, and complete the section about any co-accused in the matter.
With all of this in mind, it's important to note that there are no ethical differences between representing children and representing adults. As an advocate for a child, you should act on their instructions. You act on a direct representation model, as you would for an adult client, and not on a best interest model. You are bound by their instructions. This means that you must act on their instructions even if you personally believe the course adopted is not in their best interests. The usual confidentiality and legal privilege issues also apply when dealing with clients that are children. There is no requirement to have an adult or support person present when you are conferencing your client. It is your client's choice whether they want to allow their parents or carers into these discussions, and no one else's. Young people should be advised in private about privilege, and you should first seek their informed instructions about whether they want other people to participate in the conference. Even with a child's consent, in many cases it's preferable to discuss the case with the parent or carer afterwards. This ensures that you can obtain the young person's instructions without any external pressures from the parents or carers. As a duty solicitor, you will often be asked to do fresh custody matters. It is important that you take instructions on the substantive charges and not just on the release application. You need to make sure that you progress the matter where possible. For example, by ordering a background report for sentence, or seeking brief orders, or fixing a hearing date. Unless there are extenuating circumstances, you shouldn't simply make the release application and adjourn the matter for instructions. Simply adjourning matters where a young person is bail refused, even for only a week, can often mean that a young person will spend additional time in custody. Any time that a child spends in custody is extremely significant.
Absolutely. Further to your point on taking instructions for release applications, there is also significant importance in finalising matters on the day. If the young person instructs you that they wish to plead guilty, you should absolutely try to finalise their matters where possible. Most sentences received in the children's court are non-custodial, so having them sentenced saves them from coming back to court. And if they're in custody, it will save time for you in making a release application. Section 25 of the Children Criminal Proceedings Act 1987 deals with background reports. You should be aware that if a court is contemplating a custodial sentence, then the court must order a youth justice background report before imposing a control order. This is found under Section 25(2) of the Act.
If you have obtained instructions to write representations to the police about the charges or facts, it's important that you draft them on the day of your duty appearance. Where possible, it is also best practice to send them to the police on the same day. When drafting representations, you should advise the police to respond to the reps at the relevant legal aid office that has arranged your duty appearance. Sometimes you may prefer to have your written representations reviewed before sending them to the police. In these instances, you should email the representations to the legal aid managing solicitor.
There are some important differences with bail applications in the children's jurisdiction. When applying for bail in the children's court, you should note the following. Do not put off applying for bail due to Section 74 of the Bail Act, which allows only one bail application without a change of circumstances. Section 74(3)(d) of the Bail Act 2013 allows a child to make subsequent application for bail without new facts and circumstances if the previous application was made on the first appearance of that offence. This is particularly relevant if your client was denied bail at weekend bail court. The show cause provisions do not apply for children in any circumstances. This is seen under Section 16(a) of the Bail Act. Familiarise yourself with Section 28(3)(a) of the Bail Act, which allows the court to grant bail on the condition that the Department of Communities and Justice or Youth Justice can find suitable accommodation for the young person. These accommodation requirement conditions are unfortunately all too common in the Children's Court. And if a child is bail refused, you can request that the matter is adjourned for a week and ask the court to request a bail support plan from Youth Justice. This can help overcome any Section 74 issues. Magistrates are often more likely to return a young person to bail, especially after a breach only, if they have spent a week in custody. The Children's Court has a range of sentencing options available, some of which are equivalent to those in the adult jurisdiction and some that are not. For example, a Section 9 Conditional Release Order of the Crimes Sentencing Procedure Act 1999 would be the equivalent of a good behaviour bond under Section 33(1)(b) in the Children's Criminal Proceedings Act 1987. The Young Offenders Act 1997 and Section 33 of the Children's Criminal Proceedings Act 1987 set out most of the Children's Court's penalties. For obvious reasons, there are significant differences between the sentences imposed in the Children's Court and the local court. For example, Section 33(1)(b) of the Children's Criminal Proceedings Act 1987 provides that even though suspended sentences are no longer available in the adult jurisdiction, they can still be imposed in the Children's Court. It's also worth noting that under Section 54(d) of the Crimes Sentencing Procedure Act 1999, standard non-parole periods do not apply to children. The Children's Court places greater weight on rehabilitation than the local court. This is restated in the decision of Paul Campbell and the Queen, 2018, New South Wales Court of Criminal Appeal, 87. For sentencing procedures in the Children's Court, you should also familiarise yourself with the principles found under Section 6 of the Children's Criminal Proceedings Act 1987. These set out that children have rights and freedoms before the law equal to those enjoyed by adults and, in particular, a right to be heard and a right to participate in the processes that lead to decisions that affect them, and children who commit offences bear responsibility for their actions but, because of their state of dependency and immaturity, require guidance and assistance. It is desirable where possible to allow the education or employment of a child to proceed without interruption and for a child to reside in his or her own home. The penalty imposed on a child for an offence should be no greater than that imposed on an adult who commits an offence of the same kind. It is desirable that children who commit offences be assisted with their reintegration into the community so they can sustain family and community ties and accept responsibility for their actions, and, where possible, make reparations for their actions, and, subject to the other principles described above, consideration should be given to the effect of any crime on the victim. Even magistrates of the Children's Court, who sit in the jurisdiction full-time, should be reminded of these principles. The principles about residing in their own home and having their education or employment uninterrupted are very useful when making release applications.
The Young Offenders Act is intended to provide diversionary measures for the police and the court in dealing with children who have committed offences. Not every offence is able to be dealt with under the Young Offenders Act, though. Section 8 of the Act sets out what is covered. Offences that cannot be dealt with under the Young Offenders Act are strictly indictable matters, sexual offences, and offences under the Crimes, Personal and Domestic Violence Act, like stalk, intimidate, or contravene AVO. Also, only certain drug matters can be dealt with under the Act. The two main Young Offender Act dispositions that you will come across are cautions and youth justice conferences. A caution can be given by the police or by the court, where the offence or offences are admitted by the young person. If a caution is given, the proceedings are dismissed. A youth justice conference is a meeting organised by Youth Justice that the young person must attend. The young person can bring a support person to this meeting. Other parties who attend the conference include the Youth Justice convener, a representative from the police, and the victim of the offence or a community representative. At the conference, the young person is expected to apologise for their actions, and the various parties will have a chance to talk about how the offence has impacted them. The parties must then agree on an outcome plan. An outcome plan is a list of things that the young person must agree to in an attempt to make it up to the community. Common aspects of outcome plans include agreeing to counselling, writing an apology letter, and sometimes volunteer work. The young person must agree to the outcome plan, and then the convener will inform the court whether the young person has completed the outcome plan. When they do, the court will dismiss the charges.
The doctrine of Dolly Incapax can seem like a strange concept for practitioners who have not frequently acted for children, and there are often misconceptions about it. Dolly Incapax is a rebuttable presumption that where a child is under 14 years old, they do not have the necessary mens rea to commit offences. That is, they do not appreciate or understand that the act was seriously wrong. To rebut this presumption, it must be proved that the child did understand that the act was seriously wrong at the time of the offence. Dolly Incapax is an element of the offence. It is, and should be, difficult to rebut. It is not a defence. It does not need to be disclosed to the prosecution or the court. As with all other elements, it is for the prosecution to rebut the presumption beyond a reasonable doubt. When the child would have been under the age of 14 at the time of the offence, be conscious that Dolly Incapax is an issue. It is wise to always double check the age of your client, as the police can, facts, and/or criminal history can often record an incorrect date of birth.
A provision that is unique to criminal matters involving children is Section 13 of the Children's Criminal Proceedings Act 1987. This provides a broad exclusion that anything a young person says to the police, in the absence of an appropriate support person, cannot be used in evidence against them. For the police to use evidence obtained in this way, they would have to satisfy the court that there was a good reason for there to not be a support person present, and that it should be allowed in all of the circumstances. It is worth highlighting that this covers more than simply admissions, and it includes any statements or information given to the police. There is a presumption that the evidence shall not be admitted unless certain conditions are met. It is not a discretionary may not. Children are also entitled to have access to the Legal Aid Youth Hotline when in police custody. Regulation 29 of the Law Enforcement Powers and Responsibilities, Regulation 2016, provides that the custody manager must assist children to exercise their rights under Part 9, including their right to make a telephone call to a legal practitioner, support person, or other person. When obtaining instructions from a young person, you should also check with them or their legal aid records to see if they had access to a hotline call, what the advice was, and what was recorded in the custody manager's records. There will be a case where a child has made admissions by way of an ARESP, but did not have access to the hotline without a reasonable excuse. This could be because the hotline does not run 24 hours a day on weekdays, or because the police were informed by the hotline solicitor that the young person did not wish to participate in the interview. These circumstances can be used as a basis for that interview to be excluded. This is set out in the matter of the Queen and FE 2013 New South Wales Supreme Court 1692, which involved the exclusion of 2 ARESPs of a young girl charged with murder.
There is a unique process for dealing with AVOs in the Children's Court. This is set out in Children's Court Practice Note 8. Where an AVO is sought by the police, rather than the usual process of agreeing to a lengthy final order or contesting the AVO at a hearing, a child can consent on a without admissions basis to an interim AVO, being made for a period of 5 months. If there are no issues between the parties for the duration of that interim order, then the parties do not need to attend court again and the police will withdraw the application. At Parramatta Children's Court, the AVO callover sits every Thursday and is presided over by the registrar. The police also have access to a Domestic Violence Liaison Officer, or DVLO, on these AVO callover days. If your instructions are that the PINOP does not want the order or wants some conditions to be varied, AVOs can be adjourned to these lists for the DVLO to obtain instructions. You may be asked to run the AVO callover as a duty lawyer.
It's important to understand that serious children's indictable offences, or SCIOs, are not the same as serious indictable offences. Serious children's indictable offences cannot be dealt with summarily in the Children's Court and will be subject to the EAGP committal process. Serious children's indictable offences are defined in Section 3, Definitions of the CCPA. These are offences that are punishable by 25 years imprisonment or more, aggravated sexual assault offences under 61J of the Crimes Act, including attempts, unless the circumstance of aggravation is the victim being under 16. Assaults with intent to have sexual intercourse under Section 61K of the Crimes Act, including attempts, and offences under the Firearms Act 1996 relating to the sale and manufacture of firearms that are punishable by 20 years imprisonment. For example, supplying firearms on an ongoing basis under Section 51B. The statutory sentencing discounts for EAGP matters do not apply to children. When dealing with SCIO matters, they should usually be adjourned to the DPP list day, which is Friday at Parramatta Children's Court, Tuesday at Surrey Hills Children's Court, and Monday at Campbelltown Children's Court. The Children's Legal Service also has a committals solicitor who will usually take carriage of these matters. There are a few key differences that you should be aware of when dealing with sexual matters in the Children's Court. Firstly, for certain sexual offences, there is a similar age defence. This is set out in Section 80AG of the Crimes Act. This states that it is a defence to a prosecution for an offence under Section 66C3, 66DB, 66DD, 73, or 73A if the alleged victim is of or above the age of 14 and the age difference between the alleged victim and the accused person is no more than 2 years. And in any criminal proceedings in which the application of this section is raised, the prosecution has the onus of proving beyond a reasonable doubt that the alleged victim was less than 14 years of age, or that the difference in age between the alleged victim and the accused person is more than 2 years. Secondly, there is also an exception for possessing child abuse material. For example, when children sext each other. This is set out under Section 91HAA. This section provides a defence to a charge of possessing child abuse material if the possession occurred when the person was under 18 and a reasonable person would consider the possession of that material by that person as acceptable, having regard to the nature and content of the material, the circumstances in which the material was produced and came into their possession, the age, intellectual capacity, vulnerability or other relevant circumstances of the child depicted in the material and the person accused of possession of the material, and the relationship between the accused person and the child depicted in the material. And thirdly, the potential for the child to be placed on the Child Protection Register, or CPR, if they plead guilty to or are convicted of certain offences. Issues of registration are complex and beyond the scope of this training film, but it is important that you keep this issue in mind. For example, you may be acting for a child charged with two separate sexual touching offences under Section 61KC of the Crimes Act that occurred a week apart. If they were to plead guilty, whilst a custodial sentence is unlikely, they would automatically be placed on the Child Protection Register and subject to reporting obligations for 4 years. In certain circumstances, a court has discretion not to treat the young person as a registrable offender under Section 3C of the Child Protection Offenders Registration Act. Even when a child's reporting requirement ceases, they would nevertheless stay on the CPR for life and likely have criminal convictions that could never be spent. Like registration issues, the recording of convictions and the impact of a child's criminal record is exceptionally complex when dealing with children. However, this is often one of the main issues that children, and especially their parents, will take into account when a young person is considering whether to plead guilty to an offence or not. As part of this training module, you'll have access to many excellent resources on children's criminal records, including the Children's Conviction and Criminal Records paper written by Aaron Tang and Jane Sanders, and Tim Koo's paper on the Child Protection Register.
We are fortunate to have a raft of services available at the Children's Court, and you should make full use of them. Important services to note include Youth Justice, Justice Health, and court support workers. There will usually be an intake worker from Youth Justice at each Children's Court. They can assist you in several ways, such as obtaining contact details for the young person's family, finding out information about accommodation for Section 28 bail matters, where the Department of Communities and Justice or Youth Justice can find suitable accommodation for the young person, informing you of the young person's level of engagement if they are subject to supervision, printing background reports or bail support plans, providing custody in and out records so you can determine how much pre-sentence custody a young person has served. Secondly, the Justice Health worker at the Children's Court can assist you with writing court reports, obtaining treatment plans to support Section 32 applications, confirming any prior hospital admissions or prior diagnoses, and providing background information for Section 33 applications. And finally, there is also a dedicated support worker at most metropolitan children's courts. The court support worker can assist you with locating your clients at court, referrals to appropriate services and programs whilst the young person are waiting for their matters to be dealt with, such as traffic offender programs and sometimes assistance with petty cash for food or transport.
We both thank you for listening to this presentation. We hope that this training provides you with the tools to practice in this jurisdiction and represent some of the most vulnerable members of our community. Acting in the Children's Court can be tough, but also very rewarding.
Through your advocacy, you can have a profound impact on a young person's life. Thank you.